Let's start with a new topic, chapter number 10, pleadings. Chapter number 1 to 9 we have already finished, right? So now today we are going to start with the chapter number 10, which is your pleadings. Important? Yes, ma'am, it is important. Direct from this topic, then from this chapter also, again, direct questions will be there. No such drafting or case laws are there as such, right? Direct questions you will be able to see in your exams also from this chapter. Pleadings, yes, this chapter was there in old syllabus as well as new syllabus. Both the syllabus have this chapter pleadings. Done? Okay. So let us start with this topic now, pleadings. First of all, ma'am, what do you mean by pleadings? Anyone? Ma'am, pleadings are nothing. Already half a few of the points you already know about pleadings. Just the terminologies we were not knowing, right? Pleadings are basically the statements, documents, statements in writing which you are giving, right? To plead. Pleadings are for what? That you want to start your case, right? Civil cases are there or criminal cases are there, right? For that, okay, let us come here. First of all, what happens? Whenever any case is started, how the case is started? Ma'am, we know this. First of all, plaintiff will file the plaint, correct? Plaint to the court. Court will issue summons to whom? To defendant, right? Defendant will reply to the court in what? Written statement, correct? This basic we know, right? And then this written statement, everything is forwarded, hearings will be done, the cases will be taken up, right? So that is what the pleadings are. The plaint which you are filing, the written statement which you are filing, all that are nothing but a pleading only. It is a plead. Why? Because we are requesting in plaint what we request the court. First of all, you cannot order the court. We can only the request. But in plaint, we write everything, right? What is the matter? What is the fact? What is the case? What is the point of dispute? What relief you want? You can request the court. So that means you are pleading. So this is nothing but a pleadings only. Whatever written statements you are giving, right? For each case, each party will give the statements, written statements, writing everything, that is known as pleading in simple terms. Easy? Okay. So now moving ahead. Pleading shall mean plaint or written statement. We have just discussed, right? So what is pleading? Pleading are the statements in writing drawn up and filed by each party to a case, stating his contentions will be at the trial and giving all such detail as his opponent needs to know in order to prepare his case in answer. Very important. This introduction, this definition will help you in all your answers. Remember, because I have already told you always, whenever you start your answer, you have to write first introduction. So what is pleading? Pleading is what? Pleading is a statement in writing, drawn up and filed by each party to the case. In pleading, what you will state? Stating what his contentions will be at the trial. That when the trial will start, when the hearings will be done, what my contentions will be there, what my intentions will be there, what I am going to say, right? What is the fact? What matters are there? Right? And giving all the details to the defendant. This plaint, this copy of plaint goes to the defendant also, correct? Summons plus copy of plaint. Why it is given to the defendant? So that defendant also comes to know that what plaintiff want to say, what are the facts he is saying, what is the dispute he is arising the case on, right? Why this is important? So that defendant also prepare his case, It is not a surprise for him, right? It should not become as a surprise for him. He should also be given a chance to prepare his case, right? So, plus defendant also files a written statement. Why directly not in the court? So that plaintiff also comes to know, because this copy of written statement will go to plaintiff also. So that plaintiff can also come to know that, okay, what are defendant's contentions, what are his defense, in his defense, what he is saying, whether he is putting any allegations or not, how he is defending, so that plaintiff can also get a chance to prepare his case, right? So that is why pleadings are filed. Then, and giving all such detail as his opponent needs in to know in order to prepare his case in answer, right? So that is known as pleading. So what is pleading? Pleading is what? Pleadings are the statements in writing drawn up and filed by the each party in the case, right? Why? Stating what? Stating his contention, what his contentions will be there at the trial, and giving all the details to the opponent party, so that the opponent party can prepare his case in answer. That is known as pleadings. Done? Before the trial of a civil suit starts, it is highly desirable that the court should know exactly what it has to decide upon. Plus, court should also know what is the case, what is the dispute, on what matter I have to give the judgment, decision. Court should also know. So that is why all this we file with the court, right? And the parties should know exactly what they are contesting about, what you are fighting about. The parties also should know. The most satisfactory method of achieving this object would be one by which each party in turn is obliged to state his own case and answer the case of the opponent before the trial comes on. Such statement of the parties and replies to them are known as pleadings, right? So that before trial starts, everybody is prepared. Court judge is also prepared. Both the parties are also prepared that what is the matter, what answer we have to give. You can prepare your case. That is called the pleading. Okay? So different definitions are given here. The document stating the cause of action and other necessary details and particulars in support of the claim of the plaintiff is called as the plaint. We already know. In plaint, you mention the cause of action, reason, all the necessary documents you will attach, all details you will attach, right? So that is what plaint. And the defense statement containing all the material facts and the other details by the defendant is known as written statement. We already know, right? Who will file the written statement? Ma'am, defendant is going to file the written statement. It is what? It is nothing but an answer to the plaintiff, right? In plaint, whatever is written, you have to give an answer to that. So, as an answer to the contentions of the plaintiff, and it contains all material and other objections which the defendant might place before the court to admit or deny the claim. Everything is written in that, right? Any material omission in the pleading can entail serious consequences. If you remember, we have discussed that if you don't give proper documents, proper facts, later on, subsequently, you are not allowed, right? So that means it has a serious consequence. This pleadings are not for time pass. Because at the evidence and argument stages, parties are not permitted to depart from the points and issues raised in the pleadings. You cannot raise any new point in the pleadings also, or you cannot deny also, right? Or new evidences also you cannot put. You are not permitted, right? Nor can a party be allowed to raise subsequently, except by the way of amendment or any new ground of claim or any allegation of fact inconsistent with the previous pleadings of the party pleading the same. In some cases only, right? In some cases, the court may allow amendment of the plaint or written statement on the application of a party. If you want to change, if you want to enter some new issues, new facts, new evidences, again you will have to apply that I want to make an amendment to my statement. Again, a long procedure, right? Another case of departure is where the defendant pleads for set off or that of the counterclaim. We will study this, what is set off, what is counterclaim, right? So if you do not file your pleadings properly, if you omit any important things, you will have to face a serious consequences. Okay? So that means pleading is not lightly. It is very important part of any trial. Pleadings contains material facts, contentions, and claims of the plaintiff. What are the material facts? What are the allegations I am putting? What are the contentions? Contentions means what are the discussions going to be there? And what is the claim I am putting, right? And the material facts, contention, denials, or admission of claims. Plaintiff have claimed. Now defendant will either accept, either deny. If you remember in the previous chapter also I have told you that as in defendant, for every claim you will have to mention that I accept, I deny, I accept, I deny, whatever, right? If you do not mention it, by default it will be assumed that yes, you have admitted it, your claim. Correct? So it is important. There may also be counterclaims by the defendants, which may be of two categories. A claim to set off against the plaintiff's demand, and independent counterclaim, which is not exactly set off but falls under some statute. This set off and counterclaim we are going to study. Ma'am, we know also, right? Done. So what is pleading? Pleadings are nothing but, so this is basically an introduction given to you. What are pleadings, right? So pleadings are what? Pleadings are it means a plain or written statement, right? To a document, it is a document through which what? Pleadings are the statements in writing drawn up and filed by each parties to the case, stating what? Stating what his contentions are and what his contentions will be at the trial, and giving all the details to the opponent party as well, so that the opponent party can also prepare his answer. Done. Pleadings are very important. We cannot omit any material things. Material omissions will affect you or have a great consequences. Why? Because later on you will not be allowed, nothing new issues or new matters, new evidences will be taken up by the court. If you want to take, you will have to amend your plain or written statement. But for that amendment also, you will have to apply to the court first of all. Court will allow you, then only you will be able to amend it, right? Plus, why pleadings are important? Pleadings are nothing but a written statement, so that before the trial start, court also know, judge also know what is the matter, on what matters the decision is to be given. Both the parties also should know, right? That what is the claim, what is the defendant saying, what is the plaintiff saying, what are their contentions, what are the discussions, what are the evidences they have, right? What are the facts they are putting, so that they can prepare the case properly. Done? So that is the main crux of the pleading. Okay. What are the main objects of pleading? If this question comes, ma'am, first of all, we will write the introduction about the pleading. What do you mean by pleadings? Then we will start. Okay. Then, yes. What are the main objects of pleadings? So pleadings are the main object is what? To define the issue of fact and the question of law to be decided between the parties. To give fair notice of the case which has to be met, so that the opposite party may direct his evidence to issue disclosed by them, right? So opposite party may direct his evidence. To provide a brief summary of the case of each party, which is readily available for the reference and from which the nature of the claim and defense may be easily apprehended. And to constitute a permanent record also. It will help as a permanent record, right? That what was the matter raised. Later on you will not be able to deny. So as to prevent future litigation upon matters already adjudicated upon between the litigants. So what is the main objective? It will define the issue of facts, right? To define the what are the facts, what are the matter, right? What are the questions of law. To give fair notice of the case to opposite party also, so that opposite party can provide his evidences, direct his evidence. Plus, it will provide a brief summary of the case readily available for use, for reference also. Plus, it is in writing. Everything is a permanent record, so that it will help you if any future litigation arises on any matter, right? That what was the question raised. So you can refer that. So that is the main objects of pleading. Otherwise, later on, if nothing is written, later on you will add another points, right? That is why. Now, next is what are the importance of pleadings? What are the importance? The importance of pleadings are the importance of the art of pleading is insufficiently realized in this country. It demands a high degree of skill, and the final form of any pleading should be stated only by advocates who have the necessary skill and experience. Because here proper pleadings should be there, no points should be missed out, nothing should be written irregularly, right? You have to take care of the words properly, everything should be framed properly, because based on that only your judgment will be given, correct? Your case will move ahead. So that is why pleading should be, it carries a lot of skills and professionals will do, right? No relief based on any ground not set out as pleading can be granted. We have seen this, right? Any ground which you have, any ground which you have not mentioned in the pleading, for that no relief also will be given. We have seen this, right? A party urging a ground which is entirely a legal ground may be allowed to set it up at a later stage, but plea based on a question of fact or a mixed question of law and fact cannot be allowed to be taken up at a later stage, right? Any legal grounds are there that may be allowed, but any plea for which the new question of facts are there, new questions will not be allowed, right? A finding based on no pleading and no evidence cannot be sustained. No pleadings are there, no evidences are there, it will not be sustained. So that is why pleadings are very important. Then, so that was the introduction of your pleading. Now comes very important question for your exam perspective as well. Should I start? Okay. Yes. So, rule of pleading and a rule of proof. That now pleading we have to make, so we need to know the rules, right? Evidences, rules, what are the rules necessary? So it is necessary to keep in mind the distinction between a rule of pleading and a rule of proof. That inconsistent pleading can be pleaded. It in the alternative is a well-established rule of pleading. But the proof of a plea depends upon the provision of substantive law. Don't worry, we'll study all this. Yes, fundamental rules of pleading important. 4 fundamental rules of pleadings are there. First one, only the statement of facts and not the law. In your pleading, it should contain the facts, not the law. You have to mention all the facts of the case, not the law. First fundamental rule, right? Second, the pleading shall contain all the material facts and material facts only. That means what? Immaterial things, don't keep on writing immaterial things, right? So only material facts. Third, that a pleading should state only the facts on which the party pleading relies and not the evidence by which they are to be proved. That means what? You will mention only the facts in issue. If you remember, we have studied Indian Evidence Act. So what you will mention? Only facts in issue and not the relevant facts. Only facts in issues you are going to mention, not those facts which will help you in proving. That means only facts and no evidence, not the evidence. You don't have to mention the evidences, right? Only facts, whatever the matter is there, that only you have to mention. Don't worry, all this we are going to study in detail. Fourth, that a pleading shall state such material facts concisely but with the precision and certainty. Concisely but properly, right? Uncertain things are not needed. So 4 fundamental rules are there. Out of that, let us start with the first one. What was the first rule? That you will mention facts and not the law. That is the first fundamental rule of pleading. When you write any plaint, when you write any written statement, that is the first rule. That only what? Facts should be written, not the law. Ma'am, why? Judge will say, don't explain me the law. I know the law properly. You just mention the facts. What is the law? How the law is to be interpreted? I will check that. No need for your expert advice. That is the first fundamental rule. So one of the fundamental rules of pleading is that a pleading shall contain only a statement of facts and not the law. Don't explain us the law. We know the law properly. Your work is to explain the facts. Tell us all the facts, right? Then From that facts, what are the law applicable, what are the inferences, what are the interpretations, all those things we will do. That is not your work, right? You are coming to us now, we will do that, right? So that is the first rule. Then, yes, what is the first rule? First rule is the rule of the fact. Aditi, can I just get a coffee if anybody is there? Okay, then no issues. Okay, first one, what is the rule one? Facts and not the law. One of the first fundamental rule is that you only have to mention in your plaint and you just have to mention the fact and not the law, right? So the duty of the pleader is to set out the facts upon which he relies and not the legal inferences to be drawn from them. Don't do that. All this, that is our work, right? And it is for the judge to draw such inferences. Judge will do that from those facts as are permissible under the law of which he is bound to take judicial notice. All these things judge will do. You do your work, right? Thus, where a party pleads that an act of the defendant was unlawful, or that the defendant is guilty of negligence, or that the defendant was legally bound to perform some specific contract, such a pleading would be bad. Why? You don't have to prove whether it is guilty or not. We will decide, na? That is why you are coming to us to decide that whether he has done any negligence or not, right? You just prove your facts, what he have done, right? Don't tell us that he was legally bound to do or not, correct? In such cases, the plaintiff must state the facts which establish the guilt or negligence of the defendant. That means, for example, okay, I was negligent, I was careless. I have not, let us say in my contract, I was careless there and I have given you the defective raw material. So you just have to mention this, that the Nidhi ma'am have given the defective raw material of this quantity, whatever quality is there, whatever quality we demanded and what quality she gave. You don't have to mention she have done negligence, she has done careless and all these things. No needed. Court will do that. Fine. So the plaintiff must state the facts which establish the guilt or negligence of the defendant or how the particular act of the defendant was unlawful. Of the fact leading to the contract which thus bound the defendant. Then, so some examples are given here now. Here you can write it down example. In a declaratory suit, it is not enough to plead that the plaintiff is the legal heir of the deceased. For this is an it is not enough to plead that the plaintiff is the legal heir of the deceased. For this is an inference of the law. Declaratory suit means what? Some declaration. A suit is filed. For example, let us say, some father's property is there. That is to be transferred to let us say Ankit is there. Ankit's father property, ancestral properties are there. That should go to Ankit, right? So Ankit do not have to write anything in plea that see their father's property should be given to me only as an inheritance and all. You just have to mention the fact that how you are related to this. How you are related to this property. You have to explain the relation. That Ankit will explain that he is my father, right? You don't have to explain the law. Fine. So that is given here. In a declaratory suit, it is not enough to plead that the plaintiff is the legal heir of the deceased. For this is an inference of law. You don't have to give this declaration that I am only the legal heir of them. I should only get the property. No. You just show this how he was related to the deceased. How this Ankit is related to the father. Father is dead. Now father's property should go to Ankit. Ankit have claimed for that. That is known as declaratory suit. That you declare that this property will come to me. Right? So for declaratory, you just have to explain that how you were related to the deceased. And also to show the relationship of other claimants. Let us say Ankit's sister is also claiming, Ankit's daughter is also claiming, everybody. So show the relationship, right? Ankit will show that Ankit have this three brothers name. He will mention how they are related. XYZ, he is not related to, just show the relationship of other claimants, right? And other material facts to show that he was nearer in relation to the deceased than other claimants. You just have to show this fact that how you are closer to the father as compared to other. As compared to others, how the property should come to you. You just have to give the facts. Fine. In declaratory suit, you will not explain this that see, I am only the legal heir of this the father. I only should get his property, ancestral property. No. Because why? Here you are inferring the law. You are interpreting the law, which you don't have to do. That court will decide. What you just have to do, you just have to mention the facts. That what is the fact? Ankit will tell that, see, this is my father. Right? ABC is also claiming. ABC is related. How is related? Right? So, what is the relation ABC? Let us say ABC is here. Here ABC is also claiming. Right? So, ABC is, this is son. ABC is, let us say, daughter's husband. Or you can write it down as brother-in-law. Right? So, you just explain the relations. That's it. That is your declaratory. In the declaratory suit, how you will do. Another example is given, money suit. Case is related to the money. Right? So, here don't explain the law again. Explain the facts. Right? That you just have... on money suit, it is not enough that the plaintiff is entitled to get money from the defendant. He must state the... You don't have to say. For example, I have to take money from Simran, 10 lakh. In my plaint, I will not just say that I need a money, that Simran should pay 10 lakh rupees to me. Court will say why? Explain the facts, right? That 10 lakh I need it. I am asking for 10 lakh from Simran for what? Whether I have given her raw materials, I have given her as a loan, what I have done. Why I should get the 10 lakh, right? So explain the facts. So on money suit, it is not enough that plaintiff is entitled to get money from the defendant. You just cannot say, I cannot say that I am entitled, I have the right on 10 lakh rupees, right? Thank you very much. It was okay, otherwise if she's not there.
Yeah, I made it.
Sorry?
I made it. I don't know.
That is what I'm saying. You would have not made it. It's okay. Okay, yes. On money suit, what we are saying that plaintiff is not, it is just not enough that you just say that I want money. You must state the facts showing his title to the money. That why? For example, he should state that the defendant took loan from the plaintiff. If you have taken loan, explain that you have taken loan, from what date, what was the interest rate, what you promised to return the loan, all these things, right? Because these are facts. On a particular date and promised to return the money along with the specified interest on a fixed date, and that he requested the defendant to return the said amount after such date, but when he refused to return the money, right? So all those things you have to present. If some witnesses were present when the money was lent, or when the demand was made, or when the refusal by the defendant was made, the fact should be stated. You should have to state the fact. For at the time of trial, the court may order the plaintiff to adduce the evidence in support of his statement that he rejected to give you, he refused to give you money. Who is evidence? So if anybody was there, you can mention that I asked, I'm Nidhi, let us say I asked Simran to give me the money, whatever loan she have taken. And when I asked her, I went to her office. Along with it, my manager, my partner was also there along with me. So you can mention that fact, right? And then he can rely on the evidence of the witness in whose presence he had lent money and in whose presence he has made a demand for the return for the money. So those facts you have to mention. Then you don't have to mention this, that according to Contract Act, this Contract Act, court will interfere, right? What was written in the contract, right? So just mention the facts, what happened. Next, another example is given, matrimonial petition. For example, let us say Let us say I want, why I want divorce? No, I don't want. Let us say somebody else is there, right? Okay. Yes, matrimonial petition. So now here, let us say husband and wife are there. Now wife is, for example, wife is filing a case that I want a divorce from this husband. Is that enough? Court will ask why you want the divorce. That fact you have to mention. You don't have to mention the law. That law says that I can take the divorce. Law says that a husband should not marry again, right? Your husband should not have two wives according to the Hindu law, right? Or law says that till 6 months I cannot take divorce or anything. Don't say what law is saying. Say your facts, that why you want the divorce. What is the matter, right? So that is given you. It is not enough to state that the respondent is guilty of cruelty towards petitioner. Your wife is petitioner, right? And this is what? Defendant. Defendant or respondent, he is going to respond, right? Wife and she is entitled to divorce. The petitioner must state all those facts which establish cruelty on the part of the respondent. Wife can say this, that for example, husband is doing domestic violence. Mention those facts, right? She may state that her husband is drunkard and comes home fully drunk, and in a state of intoxication he inflicted physical injuries on her. He daily drinks, he come home and then he beats. That you can mention. Should specify dates on which such incidents took place, or that the husband used to abuse her and beat her in the presence of her friends. If any friends were there, relatives are there, you can mention that. And relations, or that after her marriage she was not allowed to visit her parents, or that he was forcing her to part with her dowry. Whatever reasons are there why you want the divorce, right? Giving threats of physical beating, or that immediately after her marriage till date the respondent did not even talk to her, nor he cohabited with her. It is such facts that which can establish physical or mental cruelty, right? Which can show that yes, physical cruelty was there. Done? So some examples are given to you. Next, omission to state all the facts renders the pleading defective, whatever inferences of law might otherwise have been pleaded. If you omit some facts, right, what will happen? Pleading is defective, and based on this only court is going to interfere. Court is going to make interpretations, right? If you mention half of the facts, may be possible interpretations go wrong, right? Or some fact, if you have omitted all the material facts, such a plaint may be rejected on the ground that it disclosed no cause of action. Wife is saying, I want divorce. I say the reason, cause of action, why you are taking such action, cause, reason, right? So, for example, in a suit for recovery of money for the goods sold, the defendant should not just take the plea that he is not liable. Such a statement is a plea of law and can hardly stand. First example we have discussed, right? For the goods, I have sent goods to Simran. Simran is liable to pay 10 lakh rupees, right? I have mentioned facts. Defendant, who's defendant? Simran. Simran cannot just say that I am not liable. Who are you to decide that? Court will decide, na? You mention your facts. That as far as the facts given by the Nidhi, yes, goods were sent by Nidhi, but they were defective. That is why they were defective. You can mention all those facts. You cannot mention I am not liable. And what court will do, right? So that is given you. Such a statement is a plea of law. We have seen. You just have to mention the facts, don't mention the law, right? In spite of this good defense, his case will fail. In such a case, the defendant must clearly state that he did not purchase any goods, or the goods were defective, whatever, from the plaintiff, nor was there an agreement to do so. He may also state that though the goods were sent to him, but he did not take the delivery, as he had placed no order, Therefore, or that the goods were sold to him on credit and the money was to be paid to the plaintiff. It was on credit only and money I am supposed to pay after 6 months only. You can mention all these facts, right? And that he was willing to return the goods of the plaintiff in accordance with the written or oral understanding that in case of goods remaining unsold, the same shall be taken back by the plaintiff. Such facts would be valid, right? So what is this seventh point? You can connect this seventh point with this. That in money suit, what plaintiff have done, right? And here they have given that how the defendant can respond. Right? So you just mention the fact, you just don't say I am not liable. Court will decide that. Next, another examples are given, suit for defamation and damages. Defamation means what? Yes. Defame means what? Harming somebody's goodwill or reputation. That is known as defamation in a wrong way, right? So another example is given. It is not sufficient for the plaintiff to state that the defendant defamed him and therefore he was entitled to damages or special damages. Don't say this. What happened? Say that. The plaintiff must state all the facts of the defendant act or acts such as his public utterances, that what he spoke in public, what he have published in the letter, right, about me. So mention all those things. In which he named the plaintiff and made remarks about his character or profession or publications in which he was painted in a manner as would in the opinion of a common man lower him in the eyes of estimation. That means his goodwill is harming, right? So wherever possible, plaintiff must give the exact words spoken, that what exactly he said, because he is harming your reputation, or what exactly he write, or you can mention in which publication it have written. All those things you can do. Or used in the entire sentence or statement, and also give the general grammatical or implied meaning of such words spoke or used, because in different language different meanings could be there. Wherever there is any ambiguity, he may take the plea of eundo and state how such a remark was commonly understood by persons known to him. Just now I told you, because some words could be there which have different meanings, right? So it might be possible that the person have used that word in a good way, but in common sense, in common how the general people use that word in a bad manner. So that created a confusion. So you can mention that, right? Thus the plaintiff should build his case on facts from which the conclusion would naturally and logically flow. So these are some examples given where they have mentioned that how you will mention your facts. Done? Yes, any doubts? Just give me a second. Done? Yes, ma'am, done. So fundamental rules. Fundamental rules of pleadings. What are the fundamental rules of pleading? Ma'am, first rule. Rule number 1. What is the rule number 1? Yes, tell me quickly. You just have to mention the facts and not the law. Facts and not law, right? So that is the rule. Facts and not law. Mention all the materials, all the facts. Done? Okay. Now, some examples we have discussed here. Example, for example, declaratory suit. Remember father-son relation. Then money suit. I have to take money from Simran. Right? Money suit could be there. Then defamation. What words here that person you have used? Defamation and damages. Right? Then matrimonial. Yes. Matrimonial suit, husband, wife, right? If a divorce is there, what happened? What are the facts that you have to mention? So matrimonial suit is the example, another example. So all these are the examples given. I hope this is clear. You just have to mention the facts. But exceptions. Some exceptions are there. Exceptions where you have to mention the facts plus you can mention the law also. That means what is the exception? Fact plus law also you will mention. Ma'am, what are the exception? Let us come here. First exception is foreign law, right? So that is your exception, foreign law. If any matter is related to the foreign law you can quote, right? Because we are Indians, right? In India, the case is going on. So it might be possible that foreign law, we don't know. We had to refer. So you can mention the foreign law. That is allowed. That what law says there, right? So that you can, that is allowed. Because contracts can be made in foreign also. So if the foreign law is involved, you can do. Second is your customs. Why? Because every village, every city, every town have different customs. How judge will come to know, right? Especially in small villages, there are different customs which everybody follows. So those customs are there. Then, for example, let us say matrimonial, this marriage. Our custom is that you take that 7 feras and marriage is done, right? That is a custom. No need of registration in my village, for example, right? So that is the custom. That 7 feras are done, even though you have not signed the marriage papers and all, still marriage is done. That is, so whatever the custom is, you have to mention that. For example, in Muslims, there is like 3 times you speak divorce, and divorce is done. Now things are changing. So if any such customs are there, that you have to mention, right? Third, if any matter is there which involves fact also and law also, that our question itself is on law. We are confused about law also, right? So mixed question of law and fact. Fourth one, legal pleas. Legal pleas, where the question dispute itself is of the legality of law, whether this law is applicable on me. That is only the question. If question itself is on law, you have to mention that what is the dispute, right? So that case. And the fifth one, what is the fifth one? Inferences of law. Yeah. So at some cases, some exceptions are given where you can mention the facts plus law also, right? Depend on case to case. So that is given. The rule that every pleading must state facts and not law is subject to following exceptions. Foreign law, custom, mixed question of law and fact, legal pleadings are there and inferences of laws are there. So in such cases, what you will do, you will mention the law plus fact. Otherwise, what is the general rule? Ma'am, general rule says mention only the facts and not the law. Law, court will check, right? Court is saying that I know the law. Don't explain me your law, right? Then, so that is the first fundamental rule of pleading. Any doubts? So direct question could be asked, what are the rules of fundamental pleading? What are the fundamental rules of pleading, right? So you have to explain that. And if individually is asked, you can write 2-3 examples. Then with the first rule, any doubts? Now let us come to second, material facts. Okay, let us come. Rule number 2, material facts. Ma'am, what do you mean by material? Material we know, important. In general language means what? Whatever important things are there, mention all those facts. First point is saying mention the facts. Second rule is saying all the material facts. Right? Okay. The word material means necessary for the purpose of formulating a complete cause of action. Whatever those information which are necessary, that is material. Cause of action means what? Every fact, what if traversed, it would be necessary for the plaintiff to prove in order to support his right to the judgment of the court. Every fact, cause of the fact, you have to prove. You want, let us say, I want 10 lakh rupees. For that, what is necessary? Giving the reason, right? Plaintiff have to give the reason to support his right. I want that yes, judge should give the decision that I have right on 10 lakh rupees. But what will support the reasons? So that is known as cause of action, which we know. We have already studied all this in executive as well. When a litigant comes to a legal practitioner, he brings all the facts and circumstances pertaining to the case. In fact, he tries to narrate each and every event. Any client will come to you, he will explain everything. From that, you should know what is material, what is immaterial. Now he is mentioning I was sleeping at night for 8 hours. Now that is not relevant for your case. Ignore that, right? Which may possibly have a remote bearing upon the case. Remote means very little bearing. Not all such facts are important, right? If everything were to be included in the plaint, then the plaint is likely to become so voluminous that the learned judges it likely to miss the essential track. If you write down each and every point, for example, in morning I went to at 7 o'clock I did brush, at 8 o'clock I went to the office and all. Not needed, right? Because if you will write each and every small fact, the main efficient important thing will be missed out by the judge because it will become so voluminous, so huge, right? And be guided by inessentials, and court will be able to see only unimportant things, and which is not our purpose, right? What is necessary therefore are the facts which are material, facts which have a direct and immediate bearing on the case, facts which are secondary or incidental may easily be omitted. Yeah? Of course, the lawyer must weigh each fact and test its significance and relevance in relation to the given case. Lawyer will check properly that whether it is relevant or not. Marshalling of facts is what a good lawyer would always do before he sets them down in form of a plaint. What marshalling of facts means? What? Checking. Lawyer will not write all the facts, keep on writing. First, he will analyze that whether these facts are relevant or not, whether this fact should be put in the plaint or not, right? This rule is embodied in order number 6, rule 2, and it requires that the party pleading must plead all the material facts on which he intends to rely for his claim or defense. You have to mention all the material facts on which you rely for the claim or defense because both the parties filed. He must plead material facts only, and no fact which is not material should be pleaded. Nor should the party plead evidence nor the law of which a court may take a judicial notice. We already seen you don't have to plead the evidence or the law. Court will interfere the law. Whether a particular fact is material or not, that depend on case to case, right? Now, may be possible. A fact may not appear to be material at the initial stage. At the starting, we are thinking that this is not that much important. Later on, it may turn out to be material. Possible, right? So, if you are not able to decide whether the fact is material or not, better what to do? Better include it. If you are not able to decide, or if he entertains a reasonable doubt as to the materiality, you don't know whether it is material or not, right? What you would do? It would be better to include them than to exclude. Why? Ma'am, we know this, that if you omit right now, later on if it becomes important, court is not going to allow you. New facts, new evidences, court will not allow, right? So if you are confused, better include it, right? Because if a party omits to state or plea any material fact, he will not be permitted to adduce evidence later on. right? To prove such a fact at the trial, unless the pleading is amended. Unless amendment, but for amendment, again, you will have to apply to the court for amendment. Correct? So better if you are confused, include it. So what is the general rule? A party cannot prove a fact which he has not pleaded. So if you miss out any fact, later on you will not be able to prove also, and later on you will not be able to claim also if you missed out. For example, fact. I wrote that yes, Simran is supposed to give me 10 lakh rupees. But I missed out that additional 1 lakh interest is also there. Now, forget about 1 lakh rupees because I did not mention the fact. And if I don't mention the fact, later on I am not allowed, right? So all the material facts should be included. Right? So that is your materiality. Right? So, okay. So here we can write it down. What is the second rule? What is the second rule? Material facts. So first of all, material means what? All the necessary, important. Right? What is material and immaterial depend on case to case. Right? So include, what you will include? Include all the facts whichever direct which have direct bearing on the fact, direct and immediate implication. Right? What you can omit? You can omit the secondary facts or incidental facts. Omit secondary or incidental facts. Then whether it is material or non-material depend on case to case, right? Yes, if doubtful on materiality, then what will we do? Then what is the better option? Then better to include in plead rather than excluding, because we know the reason. Later on, I will not be allowed. Then all the material. For example, in defamation case, material, what is material? Words used. Whatever words you are using for me, that becomes material, right? Same if it is a case of, let us say, this money suit. Maybe the words may not be that much material, right? So depends on case to case. Till now, I hope this is clear. What is rule 1 and what is rule 2? Now let us see some exceptions. Some exceptions we will see, some examples we will see now, right? Okay. Ma'am, do examples separately are they going to ask? No, obviously not separately, they will not ask. But related to that, then if any cases, similar cases that, or if separately a rule 2 is only asked, then you can write such examples and explain. See, some examples are there. In a suit for damage for injuries sustained in a collision, the plaintiff in framing his statement of claim should set out the circumstances of the collision so far as they know to him with clearness and accuracy to enable his adversary to know the case he has to meet He should also state in particular terms the particular acts of negligence which according to him caused the collision. Collision means what? Two people came together and did the frauds. So what are the circumstances? You have to explain that, right? In a suit for ejectment of a trespasser from the land and for injunction, it is material to allege that the defendant threatens and intends to repeat the illegal act. Case is for what? Ejectment of trespasser. Trespasser is, who is the trespasser? Who is entering my property without my consent, right? So this becomes also very important. And I want injunction, stay order, that this person should not enter my property. I will have to, this fact becomes important, that he is threatening me, that he intends to repeat this trespassing, illegal. Trespassing is illegal, right? So you have to mention. Similarly, if a party seeks a stay order against any authority's act of demolition his premises, shop or building, he must allege that he is the owner of the property. What is the case? You want the stay order on what? The authority. For example, government authority is demolishing my property. So I need to explain this fact that yes, I am the owner of the property. Which property they are demolishing? How much part? Right? I need to explain that. And the plans or the map thereof was duly sanctioned by the appropriate authority. How much they are paying me for this demolition. Right? So all those things you need to explain. Or if a government land, he must allege that he has been in undistributed possession thereof for over 12 years. Undisturbed, sorry. Such facts are material because if proved, they will establish the cause of action. Since 12 years, I have used this government property, government land, undisturbed. Government have not disturbed me. Government did not come to me anything, right? So after 12 years, law of limitation says that you can use it as if it is your properties only, even though it is not yours. Because 12 years, I am using the property, nobody is saying anything, right? So all these points become important. In a suit for defamation, it is material to allege that the words were intended to defame the plaintiff, or at least they were so understood by men at large, general people. That if the words are ambiguous, then innuendo must be pleaded that they were ironically used or were intended to do so. What words in case of defamation, it becomes important, right? Then, when a party claims the benefit of a special rule or custom, if any, because different people have their different, for example, by default, there is a custom of giving 2 months credit period. Custom. So I need to mention all the facts, right? All the facts which bring the case within the ambit of that special rule. I will have to mention that yes, both the parties belong to the Bangalore only, and in Bangalore, this is the custom. Custom, you can explain the law, remember? Right? That is a general custom that everybody gives the 2 months credit period. Right? See, here example is given of marriage. Marriage between two sapindas or between the two persons within the degrees of prohibited relationship is challenged in some property matter. The party that is challenging the validity of marriage must allege that there was no custom governing the parties which permitted or sanctioned such a marriage. If marriage is done between the two parties which are of different caste and which is not allowed in the custom, right? So you will have to explain that. It is material to allege the existence of a long established family or caste custom governing the parties to the marriage which permitted or sanctioned. Then money suit is given. It is material to allege part payment. I've told you, principal plus interest. So interest also becomes important. I need to mention that. And also any other fact which gives a new lease of 3 years time to loan in order to save the suit from bar of limitation. Bar of limitation is 3 years, that within 3 years if I have not claimed, my right is gone. So this also becomes the important fact that yes, within 3 years only I have asked her. I gave the notice also. When a plaintiff bases his claim on some document, it is material to state the effect of such a document. For example, where the case is based on sale deed, it is material to state that a particular person has sold property to him by a sale deed on whatever date, whatever is registered, everything. Next, in a suit for specific performance of a contract, It is material to allege that the plaintiff has always been willing and is willing to perform his part of the contract. That I was ready to perform my contract. I will need to explain that, right? Because if I am only not ready, how can I claim from others? Indian Contract Act, specific performances, right? So some examples are given that all this become the material. This also becomes material that yes, I was ready to perform my part. Because otherwise, what if later on he denied? Now, some examples are given which are not material. Not material. See, in case of a promissory note itself means what? I promise to pay, correct? I undertake to pay. For example, here, Simran made the promissory note. I promise to pay 10 lakh rupees. Now, in that case, I don't need to demand. It is by default Simran is promising. Whereas in bill of exchange, I need to demand, correct? So in promissory note, it is not necessary to mention this fact. It is not material to state that the plaintiff requested the defendant to make the payment and he refused. Why? Because no demand is necessary when promissory note due date comes, you have to pay immediately, right? So here you don't need to mention that, see, I called Simran 3 times, I have sent a mail, I have sent a notice, because promissory note itself means that. Right? So here, this becomes immaterial fact. So next, in a suit for recovery of money. See, one example is promissory note. Next is your recovery of money. Recovery of money for what? I have sold the goods. So here it is not material to mention that goods belong to me. It belonged to me. That is why I have sold the goods. Right? So not material. It is not material to state that the goods belong to the plaintiff or that the goods were sold to the defendant on the belief that he would honestly make the payment. That is by default understood. That why I have sold the goods, so that you will make the payment. Correct? Next, damages. General damages are presumed to be the natural or probable consequences of the defendant. Such damages need not be proved. But if special damages are there, that needs to be proved. Some damages are there by default, you don't need to prove it, right? For example, here. If you remember, we have discussed about special damages also. That, for example, because of me, if you remember, we have seen an example of a tailor also. The tailor sent the goods to the railway so that to deliver it on time because of some festival was there, right? So whatever loss the tailor faced because the goods were not transported, that is general damage. But because of that, tailor did not receive any more orders. That is special damage. So special damages you need to mention it. But special damages need not be presumed by law to be the consequences of the defendant's act, but will depend on special circumstances, right? So that means what? General damages not to be proved. Special damages, yes. Therefore, it will have to be proved at the trial that the plaintiff suffered the loss and also that the conduct of the defendant resulted in the loss so suffered by the plaintiff. You will have to explain special damages. In such cases, the proof of special damages is essential to sustain. A person has no right of action in respect of a public nuisance unless he can show some special injury to himself, which is over and above what is common to others. For example, noise pollution. Because a party is going on, everybody, let us say any festival is there. In festivals, noises are coming. But if you want to claim, which is common for everybody, but if you want to claim some special damage, you will have to show that because of so much noise, I became deaf. That is a special injury, right? So that you will have to show. That becomes material and it is not for common for others, right? So that is special damages. Done? Again, what is rule 2? Rule 2 is material facts we have to mention in our pleading. All the material facts. If we are confused whether it is material or not, or if we think that right now it is immaterial, but in future it may become material. In that case, what we should do? Better to include. Why? Because what is the general rule? If you are not mentioned in the pleading, you cannot prove it. Related to that, whatever evidences are there, if you have not mentioned the fact, evidences related to that also will not be allowed in the court later on, right? Then some examples are given. What is material, what is immaterial? All the examples also we have discussed. Now, important, another exceptions. Some exceptions. First one. Second fundamental rule of pleading is that every pleading must state all the material facts and the material facts only, right? But some exceptions are there. First one, condition precedent. Ma'am, what do you mean by condition precedent? Anyone? Condition precedent means what? Before and only if any conditions, terms, and if we have put a condition precedent beforehand, that need not be mentioned. Right? So that is known as condition precedent. General rule says that that is not important. But if it is material, yes, you will have to mention. So let us see what is given. Condition precedent. The performance of occurrence of any condition precedent need not be pleaded, as its averments shall be implied in the pleading. But where a party chooses to contest the performance or occurrence of such condition, he is bound to set up the plea distinctly in his pleading. Separately, you will have to mention. Let us see an example. X agrees to build a house for Y at a certain rate. That is a contract made, right? A condition of the contract is that the payment should only be made upon the certificate of Y's architect, that whatever amount is due, right? If X desires to file a suit for money against Y, the obtaining and presenting of the certificate from Y's architect is a condition precedent to X rights of action. Certificate was important here, right? So you need to mention. Here it is not necessary of Y to state in his plaint that he has obtained the said certificate. He can draft a plaint showing a good prima facie right to the agreed amount without mentioning any certificate. It will be for the Y to plead that the architect has never certified that the amount is due. I hope you have understood, right? So if condition precedents are there, if beforehand conditions are there, which are by default, you don't need to mention that. So here what is happening? X have built a Y for Y. Y is the owner, X is the builder. So what was the condition? That owner is going to make the payment. But what is the condition upon giving the architect certificate? This was the condition, right? So here what is happening? X desires to file a suit for money. X is filing a case that Y is not making the money. The obtaining and presenting of the certificate from Y certificate is a condition precedent to X right of action. When X can take the right action? Depending on certificate. Here it is not necessary of Y to state in his plaint that he has obtained the same certificate. He can draft a plaint showing a good prima facie right to the agreed amount without mentioning any certificate. It will be for Y to plead that the architect has never certified that the amount is due. Yeah? Now make a correction here. Here it is not necessary of X to state in his plaint that he has obtained the said certificate. He will just mention that my amount is due, why is not making the payment. Why, when he is writing his written statement, why will plead that? That why I did not make the payment? Because architect did not give me the certificate. Then, so for X, it is not necessary to mention this about the certificate. Then, next is presumption of law. It provides that neither party need in any pleading allege any matter of fact which the law presumes in his favor or as to which the burden of proof lie upon the other side, unless the same has first been specifically denied. For example, in a suit on a promissory note, the plaintiff need not allege consideration. Why? Because Negotiable Instrument Act itself raises a presumption in his favor. Simran is promising me, by default it raises that, yeah, what is the presumption? That yes, this promissory note is made in my favor, I should get the consideration. So by that is some presumption by default. It is also not necessary to state that the defendant executed the bond of his own free will and without any force, because anyway force is there, free will is not there, that contract itself is invalid or voidable. Correct? So you don't need to mention that, because the burden of proving any fact invalidating the bond lies upon the defendant. If that defendant will prove that, see, I was forced, you prove, why should I prove? Right? By default, it is a presumption of law. Then, third, matters of inducement. Inducement basically means what? Introductory matter. For example, name of the parties, relationships, all this thing. Now, yes, if my name, I mentioned Nidhi Parak, but now my name only turned out something different, that becomes material. Otherwise, my name, age and all, that is just an introductory matter. Correct? So, another exception to the general rule is regarding facts which are merely introductory. Such facts only state the names of the parties, their relationship, profession, and circumstances as are necessary to inform the court as to how the dispute has arisen. Basically, a general introduction. Such facts are hardly necessary or material to the pleading, but they are generally tolerated and are set in the pleading by both the parties. In why we are writing? So that it becomes easier. So for the court also to understand the terms and condition and relationship. It is better if the prefatory remarks are cut down to the minimum. So don't mention everything in detail. Cut down to the minimum, because these are just an introduction, right? But yes, if my name itself is wrong, that becomes material. Correct? Then, so these are some exceptions. Exceptions of what? That what material facts are not needed, that you don't include, then also it's fine. Right? First one, what are the exception? Condition precedent. I will not include in my plaint. You include, you have the problem. You include it, right? Second, presumption of law. Third, for example, presumption of law. I don't need to mention that I am assuming that, okay, this person XYZ is a major. By default, if we are making a contract, by default, it is understood that yes, you are 18 plus, right? Now, if you are claiming, if you are saying that contract itself is invalid, in your defense, you will mention that see, I am minor. You write down in your defense, right? I am not going to write that presumption of law. And third one is matters of inducement, introductory matters. Then, so that is your rule 2. Then some examples are given which facts are material, which facts are not material. So we have discussed that also. Done? Any doubts? What is rule 1? Ma'am, rule 1 says facts only you have to mention and not the law. Some exceptions are there. What are the exceptions? Foreign laws are there, customs are there, where the mixed question of law and fact is there, legal pleadings are there, and inferences of laws are there. Done? Then second rule says material facts only. Immaterial things, ignore. Material means necessary, which are necessary to form a cause of action. That is known as all material fact. If you are confused, better include it, right? Secondary facts, incidental facts, you can omit. Exception, then what are the exceptions? That where the facts which you don't mention, still it's okay. Condition precedent, presumption of law, and matters of inducement, introductory matters. So that is the second rule. Now let's come to third rule. Facts, not evidence. What is the third rule saying? You just mention the facts, not the evidence. Evidence we will see in the hearings, right? The third fundamental rule of pleading is that only facts must be stated and not the evidence. As there is a tendency among the litigants to mix up the bare facts with the facts which are in reality the evidence. Because what litigants means what? Those who are putting the litigation. It is generally what? They mix up everything. Facts, evidence, everything. So what is the third rule of pleading? Mention only the facts and not the evidences. Done? For example, let us say a murder case is going on, right? So you mention the fact that okay, XYZ was murdered, right, at whatever location was there. You found out a knife, right, where fingerprints were also there. Fingerprints on knife were there. So what is this? These are facts. These are facts, right, ma'am? But this is the fact which will help in this, right? So this is known as fact in issue, and this is facts as evidences. Understood? So initially what you will do, only the facts we will narrate. Later on, the facts which will help you to prove it. That means this fact is helping me in the case to prove the fact in issue. This is the issue. This is helping the case. So then later on you will narrate this. So what the CPC is saying? Every pleading shall contain a statement of the material facts on which the party pleading relies for his claim or defense, but not the evidence by which they are to be proved. Don't mention that evidence by which you are going to prove your facts. Fine. At the initial stage only, the former facts have to be narrated. And when the state of evidence comes, then you mention the other facts, right? Then the other facts will be represented as a part of evidence in order to establish the first set of facts. Initial set of facts you have mentioned. Later on, when the evidence stage comes, then you mention the other secondary facts. Why? Because if we allow, there will be no limit only to prove the evidence. For example, video cameras were there, right? So let us say CD of that camera, recording. All these are what? Evidences which will help you to prove the facts. Then, so the reason behind the rule stating the evidence is that if the evidence were allowed to be stated in the pleading, then there shall remain no limit of detail only. And the chief object of pleading would only disappear because there is no limit on evidences, right? Evidence also consists of facts. Then how to distinguish between two kinds of facts, material facts and evidence? So in Ratilal versus Raghu, the question was just answered thus: material facts are those facts which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. Material facts, those facts which plaintiff or defendant, they are proving their right. Right? Evidence also consists of facts. In order to distinguish between the two kinds of facts, the material facts on which the party pleading relies for his claim or defense are called facto probenda. And the facts by means of which they can be proved, they are known as facta probentia. Both are different. Facta probenda means what? Those facts which are to be proved. Facta probentia means what? Those facts which will help facta probenda. Those facts which help to prove facta probenda, that is known as facta probentia. Done? Okay. So facta probenda means what? Which are to be proved. These are the facts on which a party relies and are ought to be stated in the pleading, which you have to prove the facts. That is facta probenda. Facta probentia, those facts which will help you to prove the point number A. These are the facts which are not to be stated, because by their means facta probenda are proved. With the help of this facta probentia only, you are going to prove the facta probenda. Right? For example, Simran was supposed to pay me 10% interest. I will write this fact. Right? Now, contract we have made. That becomes what? This is the fact we have made, that we have made a contract. I will disclose the contract. This becomes the facta probentia. Then, so just mention the fact that yes, Simran was supposed to pay me the 10% interest rate. When evidence stage comes, then you mention entire details about the contract. Then, thus these facts are the evidence as to the existence of certain facts on which the party relies for his cause of action or defenses, as the case may be. Facta probenda are not facts in issue, but they are relevant in that at the trial their proof will establish the existence of facts in issue. Sorry, this is facta probentia. Facta probentia are not fact in issue. Which is fact in issue? A. These are facts in issue. But what is facta probentia? They are the relevant facts which will help you to prove the facts in issue. Right? So this is fact in issue and this is relevant facts. No doubt in certain cases, both the facts in issue and their facts in evidences are mixed up and are almost indistinguishable, because you don't come to know. They should be stated in the pleading. See, example is given. A was married to B in accordance with a particular custom governing marriage between A and B. For example, I married to my husband according to Hindu law, right? Or let us say I am Jain, right? So as per the Jain laws, I was married. Then, so I will mention this fact. In this case, the custom is both fact in issue and a fact in evidence. Why? Because once this custom is proved, Jain custom is proved, this will also be proved that yes, I am married. Correct? Because once the custom is proved, then the marriage also stands proved. In the pleading, it is sufficient to allege that the marriage was celebrated in accordance with a particular custom. I will write down that yes, marriage was happened according to the Jain custom. At evidence stage, it will be sufficient to refer to the manual of customary law which records the custom. At evidence stage, I will show the manual of the Jain customs. Right? So that becomes the facta probenda and facta probentia. Done? Okay. So this is my third one. What is rule number 3? Yes, facts and not the evidences. So facts and not evidence. So here, what should be contained in your pleading? Only the facts and not the evidence. So pleadings should contain only facts and not evidence. Then two types of facts are there. One is what? Facta probenda, right? And another one is what? Facta probentia. Then facta probenda means what? The facts in issue. Facta probentia means what? Relevant facts, right? Facts in issue, this is to be proved, right? Facta probentia, you don't have to prove this. This helps to prove the fact in issue. Helps. Ultimate, the matter is fact in issue only. Facta probenda is only the dispute. But this facta probentia will help you to prove, right? Helps to prove facts in issue or facta probenda. Then, so we will mention facta probenda. Facta probentia we will mention at later stage. When evidence stage comes, that time we will mention, right? Why? The reason is otherwise in pleading, there won't be any limit only. So many evidences could be there, right? So that is why. Then that is the third rule of pleading, that when you write the pleading, when you make the plaint, when you make the written, because once you clear your degree, once you become a professional, clients will come that please frame the plaint for us. You should know all these rules, that you don't have to include each and everything, keep on including. No. Right? And the last rule, facts to be stated concisely and precisely. You have to mention all the material facts concisely, but with certainty, with precision. You don't have to omit anything. You don't have to include anything extra. Complete, accurate should be there, right? Every pleadings must state the material facts concisely, but with precision and certainty. It is a rule to be observed in all the courts that a party complaining of an injury and suing for redressal can recover only secundum allegata et probata. What is this? Secundum allegata et probata means what? Only those injuries, those damages you will be able to recover which you are mentioning certainly, properly, right? The material facts should be stated in the pleading in a concise form but with precision and certainty. That the pleading should be divided in paragraphs numbered consequently, dates, sums and numbers shall be expressed in figure as well as words. Generally we write in words also. What this rule means is that the pleading should be in brief and to the point. Don't go round and round and round. Yes. Another point to remember that is that no doubt brevity and conciseness are the rule. But in brief you have to explain, concisely you explain. But that does not mean that you don't give any clarifications only. Or you write half of the things only. Right? But brevity should not be at the cost of precision or clarity. That does not mean that you write in any way. Right? So that is your rule number 4. That it should be concise, precise. So some points are given. What you will take in. Name of the person, places should be accurately given. Correctly spelled. Spellings adopted at one place should be followed throughout. Fact should be stated in active and not in passive voice. Ma'am, before also we have studied when we make the drafting. Right? All circumstances and paragraphs should be, paraphrases should be avoided. Terse, short, blunt sentences should be used as far as possible. All its and buts should be avoided. Right? Pronouns like he, she, that should be avoided because that may create confusion. That is why in drafting always be right. Mr. X, seller. Mr. X, buyer. Seller, buyer we write. You don't write he, she. It may create confusion, right? Anyway, such pronouns when used should clearly denote the person, and clarity should be there if you are using it. Plaintiff and the defendant should be referred not only by their names. It is better to use the word plaintiff defendant, because again and again you will have to go and check who was Mr. X, who was Mr. Y. So better use plaintiff defendant. That is why we use seller, buyer, leaser, lesser, lessee, right? Because draftings are not just only half page or one page. It may go into number of pages. Again and again you will have to check who was Mr. A, who was Mr. Y, right? Things should be mentioned by the correct names, and description of such things should be adhered. Where an action is found on some statute, exact language you have to mention. If you are mentioning any law, same language you have to use, right? The use of if, but, that should be as far as possible avoided. Such words tend to take away the certainty. It is not that if this happens. No. Pleading means what? That this happened, right? So don't mention this. Necessary particulars of all the facts should be given in the pleading. If such particulars are quite lengthy, you can attach schedules, amendment, addendums, right? We know this. Every pleading shall, when necessary, be divided into paragraphs. We have seen this. Paragraphs, numbers, headings, titles, so that it becomes convenient. Numbered consequently, each allegation being so far inconvenient contained in the separate paragraph. Whatever allegations you are putting, put it in separate paragraph, so that the defendant can also accept or deny accordingly, right? The division of the pleading into paragraphs should be so done so as to ensure that each paragraph deals with one fact separately, so that it becomes easier for everybody. At the same time, the entire pleading should appear a running and well-knit manner, basically in logical manner, right? You will frame a logical manner. Must look into the isolated fact placed together. Interrelationships of paragraph must seem to exist. I always told you, right, that we write penalties later on in drafting also. Similarly, here also, pleading when you are making, mention the facts so that they are related to each other. Correct? All the relevant facts must be stated in strict chronological order. What happened according to that, you will mention. Then, date, sums, numbers shall be expressed in pleading in figures as well as in words. Done? So that is your rule number 4. Ma'am, what is rule number 4? That facts to be stated concisely, but precision should be there, accurate. But with precision and certainty. That is your rule number 4. And for that, some points they have given that how will you do the pleading? Simple. How will we do the pleading? Mention all the certain facts. Don't use if, but, he, she, such words. Write the plaintiff, defendant. Use such words. Or if criminal law is there, complainant or accused, right? Spelling should be proper. What spellings you are using, continue with that only. Use active voice as compared to the passive voice, right? Dates, figures are there, mentioned in the words as well as figures also. If any law is there, law language, same law, correct language should be there, right? If, but, all those things, because it creates uncertainty. Divide into paragraphs, make the numbers, fact should be in chronological order. Some relation should be there with the paragraph. It is not that randomly you are writing anywhere, correct? So all these points you will take care when you are drafting a plead. Done? 4 rules, 4 fundamental rules. Yes, just go through it, what we have done till now. Any doubts, any queries, anything? Yes. So till now, I'll just quickly go through what we have done, then we'll move ahead with other rules. First, we started with, ma'am, what is pleading, right? Pleadings are basically nothing but written statements which are filed by the plaintiff and defendants both, right? Because these statements will help you to present the facts, plus both the parties as well as the court will be prepared Along with accordingly, you will be able to prepare your case. That is the main purpose for the pleading. Plus, it will save the time. We already know that, okay, what should be there, right? Then important things we have done about what are the benefits, what are the main purpose of pleading, what are the importance of pleadings that we have done. Then we came to the rules of pleading. What are the fundamental rules of pleading? Ma'am, 4 fundamental rules of pleading are there. First rule, only mention the facts, not the law. Some exceptions are there. Second rule, only material facts you have to mention and not any other immaterial thing. Again, some exceptions we have seen that even though some facts you don't need to mention. Third, only facts you have to mention and not the evidence. Facta probanda and facta probentia. You will mention facta probanda and not the facta probentia. Done. And the fourth is that whatever you are mentioning, your plead should be concise but precise and accurate and certainty. Some points they have given that how you have to write it down. Done. So these are the rules. Next are the rules. Pleading will be signed. Basic. Every drafting we do the signatures. So this is also type of drafting only. So here also what are we going to do? We will wear sign here. So it makes it obligatory that the pleading shall be signed by the party and his pleader, by me and my lawyer, my company secretary, my chartered accountant who is filing on my behalf. However, where a party pleading is by the reason of absence or for other good reason unable to sign, it may be signed by any person duly authorized by him to sign the same or to sue, or basically if I have given my authority to somebody else, power of attorney, so that person will sign. Simple signature should be there. Next, verification of pleadings. Every pleading shall be verified at the foot of by any of the parties pleading or by some other persons proved to the satisfaction of the court to be acquainted with the facts of the case. Basically, this pleading shall be verified. The person verifying shall specify by reference to the numbered paragraphs of the pleading what he verifies of his own knowledge and what he verified upon on received and believed to be true. What he is verifying based on his knowledge and what he is verifying that just because I heard or I have taken expert's opinion. So you have to mention that, right? Verification will be signed. The person who is verifying it, that person will sign it, right? That pleading. The verification shall be signed by the person making it and the date on which and the place at which it was signed. Done. Next, striking out pleadings. It is no difference to an application to strike out impertinent matter. It will make the pleading inconsistent and insufficient, for the pleading should be amended if necessary. We have discussed this, that those important matters, if you do not write later on, you cannot add it. You will have to do amendment. So wherever necessary, amend it, right? Otherwise, pleading will become insufficient, inconsistent. Next, amendment of pleadings. The court always gives leave to amendment the pleading of a party. However, negligence or carelessness may have been the first omission, and however late the proposed amendment and amendment may be allowed if it can be made without injustice to the other side. When court will allow? If it does not give injustice to opposite party, right? Every time amendments are not given. Looking at the reasons, amendment will be given. The amendment introduces new case, new cause of action, new or alternative relief, correct description, change in the character of suit to be considered on the basis of the fact and circumstances of each case. Such things can be amended, right? The amendment can be allowed at any stage. Underline this. There is no invariable rule that an amendment which deprives the opposite party of the plea of limitation should always be refused. Always it is not necessary that court is going to refuse your amendment, right? But court can allow the amendment of the plaint even after the period of limitation has expired. It is in good faith how you are able to prove your mistake. Holds that the omission was due to a bona fide mistake in good faith, right? Rule of amendment of pleading is essentially a rule of justice, equity and good conscience. So based on this, court will decide that whether amendment should be given or amendment should not be allowed. So these are some other rules. Signature should be there wherever needed. Amendments, apply for the amendment. Court will decide whether amendment should be allowed or not. Why generally amendments are asked? To introduce new facts, new cases there, new action is there, new remedy you want, relief, right? Or change the description of the case. So for all those purposes. But when court will allow, if it is not creating injustice to the opposite party and if your mistake was a genuine bona fide mistake, then done. So in all such cases, it will be allowed. Otherwise, no. Next, inconsistent defenses. A defense cannot be ruled out merely because it is inconsistent with the other defense. Defense could be anything, right? We will not cancel a defense that, okay, this defense is ruled out because it is not matching with other defense. Not necessary, right? It is certainly open to a party to raise inconsistent defense in the alternative. But at the time when evidence is led, he has got to elect as to which of the alternative inconsistent defenses he is going to prove. If you are putting different which are totally opposite direction defenses, you are putting in opposite direction, and then you will only decide which defense you have to prove, because then one will be proved correct, one will be proved wrong, right? So if defenses are inconsistent, not in the same track, so law is saying that you can put your inconsistent defenses, but then you have to decide when you are proving it with the evidences that what you are proving. Then fine. So till now, any doubts, any queries, anything? Yes, students, good morning. Yes, I have tried my best to explain it in the as easy way as possible. Now you will revise it. It will take half of your time only. But please do revise it today itself. Okay. So today we will stop here only. In the next session, we'll continue with this civil pleadings and all, whatever other things are there, right? So till then, please read, revise, and come. Yes, I hope this is everything, all the topics are interesting. And now you are sorted with your drafting that, okay, what is the chapter, how you have to study the chapter. Otherwise, generally, what is the problem? What every time I have seen with the students is, ma'am, we don't know only from where to start, what to end, how to read, what to read, how to practice the drafting. So many draftings are there. Ma'am, should we practice each and every? What should we do? How to do? So I hope all your queries are now sorted, right? And you are able to study the subject properly. And now it is easier comparatively. Now, in just one reading along with me, you cannot expect that you will remember each and everything. You will have to also learn after my class. You will also have to keep on revising, of course, right? If so much such, it is not like ABCD that you will remember everything. But now it is easier. Now the subject is acceptable. What is going on, you are easily able to. Now you will be able to correct easily your drafting paper, provided along with me you are doing everything whatever I'm telling you, right? Okay, so today let's wind up here only. In the next class, we'll continue with this chapter. Let's see how much we finish. Don't know. But please, whatever we have done till now, please do revise and come so that we can move ahead without wasting much time. And then only when you have seen that I first revise. So revision will be beneficial for you if you also revise along with me. If you have also learned before me, along with me, quickly, we will revise. Otherwise, what happened? I am only revising, you are just looking like this. What is the use? The revision I am doing daily is for your benefit, not for my benefit, right? So please take advantage of that. Learn, then you will enjoy revision as well. Of course, without learning, what revision you will do, right? So please do take care of all such small things. Any other doubts, queries, anything? No? Okay. So thank you very much. Have a good day. Enjoy your days and study please properly. Thank you.